Hi everyone, good evening. All right. Okay, hello everyone. A very good evening to all of you and welcome to NLTI. My name is Mansi and we are going to continue our legal reasoning series. Okay, so now today we are here because we are going to understand about law of contract and we are going to understand how do you have to prepare and what all do you have to prepare for law of contract when you are preparing for legal reasoning section for your CLAT 2027. First of all, I'm really hoping that you're preparing well and your preparation is coming along well so far. And one very important thing that I want you to know is that contract law is again an essential part of your legal reasoning section. There can be direct questions, there can be application based questions, and you can expect at least one passage out of contract law in your exam. So now let's get started with what is something which you have to understand and which you have to keep in mind. I'll try to keep it short and crisp, but extremely insightful and useful for you. All right. So now, first things first, what is a contract? So a contract is an agreement, right? An agreement, okay, all right. So it is an agreement, first things first, right? What is an agreement? Agreement is where two people who agree to do a certain thing, right? Where there is meeting of mind. Meeting of minds here mean that one person has made an offer, the other person has accepted it, right? And when consideration is added to it, offer plus acceptance plus consideration makes an agreement. What is an offer? Any proposal made to the other party. What is acceptance? When that proposal is accepted, right? And what is consideration? Anything both the parties are getting in return is going to be the consideration. And an offer, an acceptance, and consideration together make an agreement. When that agreement is enforceable by law, which means that if you do not follow the conditions of the agreement, there can be legal responsibilities or legal consequences for the same. And when an agreement is enforceable by law, it becomes a contract. Now, in India, all the contracts are governed by Section 2H. Sorry, all the contracts are governed by Indian Contract Act 1872 and Section 2 Clause H of the Indian Contract Act 1872 explains and defines the term contract. So it exactly is what I just mentioned, that any agreement which is enforceable by law is going to be a contract. An agreement which is not enforceable by law, right? For example, now your parents, they promised you that, okay, if you score 95% marks in your exams, in your board exams, they will probably buy you a MacBook, right? Now for the same, this is not something which is enforceable in law, right? It is an agreement, but it is not enforceable by law, which means that, okay, if your parents actually do not get you a MacBook if you score 95% marks, you cannot sue them, right? You cannot go to the court asking for justice. Okay, moving ahead, what really makes an offer? So, like I already explained you this thing that, okay, an agreement is something which is made up of offer and acceptance. What is an offer? Offer is going to be any proposal made by one person to the other person. If I want to enter into a contract with you and I say that, okay, I want to sell my car to you for 5 lakh rupees, right? So I am making an offer to you. Acceptance is when you accept that offer. You agree to the terms and conditions, right? If you say that, okay, yes, Mansi, I think it's fine, I want to buy your car for 5 lakh rupees, that is going to be an acceptance. So in this case, the offer that I made to you was, please buy my car. I want to sell my car to you. Acceptance is you accepting the offer. That, okay, I want to buy your car, Mansi. Consideration is going to be those 5 lakh rupees. 5 lakh rupees for me and the car for you. So anything that we are getting in return is going to be the consideration. And when offer plus acceptance and consideration is there, it makes an agreement. Now, a lot of times, direct concept based question is there about the difference between contract and agreement, right? So agreement is going to be Agreement will consist of all these things, and an agreement which is enforceable by law, which is legally recognized by law, will become a contract. Now, offer as a concept has been explained under Section 2A of the Indian Contract Act, right? So now there are different types of offers that are there. First is the positive offer. Offer where you are promising to do something, right? Promising to do something where you are not abstaining from doing something, but you're promising to do something. For example, if you say that okay, I will sell my laptop for 30,000, you are saying that okay, I will do something, and that is going to be a positive offer. Second is a negative offer. Negative offer is when you are abstaining from doing something. If you agree that okay, watch I will not scroll Instagram reels before I sleep, right? This is you abstaining from doing something, right? Same way, if you say that, okay, I will not build a wall on your boundary, the word not is going to make it a negative offer. And for any sort of offer that has to be made, there is an intention required. Intention required here basically means that the offerer, the person who's making an offer, knows that okay, once it becomes an agreement, once it becomes a contract, there can be legal consequences. There is going to be a legal relationship that will be established, right? So an offer needs to have an intention to create a legal relationship. Now, one very frequently tested concept is difference between offer and invitation to offer. So offer is something where you are making a proposal, right? Where you are making proposal, and it will create a legal relationship once acceptance is there. Invitation to offer is probably an invitation to negotiate. You are not directly making a proposal. You are inviting them, right? Inviting them, and they may accept or reject any offer that you have made. And in the response, in what all invitation you have made, in response, they can accept or reject any offer that you have made. Now, for example, there is a restaurant menu, right? Restaurant menu is basically an invitation to offer. Now you have all the things there in front of you. Right now, you can make an offer that okay, I want probably a pizza, right? So that restaurant menu will, you are not making acceptance. They are not offering you that okay, I want to give you a pizza for 500 rupees. No, that's not what the restaurant is doing. Restaurant is giving you a menu, and you have to pick one thing among, right? And then you have to basically, they are going to serve you the same. So now you are making the restaurant menu is an invitation to offer, and you can make a counter offer there. You can make an offer that okay, I want a pizza. All right, now they can accept it or they can reject it. That's an invitation to offer. Same way, any advertisement that is made, any advertisement that you see that okay, this product has to be sold, okay, there's an advertisement and you like the advertisement and now you want to buy that product, right? So now it is an invitation to offer by the company who's selling the product, who has run the advertisement. Okay, it's an invitation to offer from their side. If you buy that product, if you want to buy that product, you will do the necessary things. Now it's going to be the company's job if they really want to give you the product or not. That's going to be an invitation to offer, right? Often the difference between the same is tested. Second concept that we have is acceptance. Acceptance is discussed under section 2 clause B. Acceptance is where the person to whom a proposal is made. So the person who is making a proposal or an offer is called an offerer. Okay. And the person who has to accept the offer or reject the offer is called as an offeree or promiser or promisee, right? So now the person who is going to accept or who's going to give his assent to the offer, right, is going to be an offeree, right? And thing that he has done is called an acceptance. Him accepting the proposal is an acceptance. Now there are certain conditions for a valid acceptance. First of all, it should be absolute. It means that it should not be conditional. If there are any conditions attached to it, then it is not an acceptance. You are accepting the offer the way it was made. If, let's say, I say that, okay, I want to sell you my car for 5 lakh rupees, and you're like, I think 5 lakhs is too much, I want to buy it for 4.5 lakhs. Now, that is called negotiation. That is a counter offer that you're making. That's not acceptance. If you say that, okay, yes, I will buy your car for 5 lakh rupees, now it's absolute. You have accepted it the way I had proposed it, right? So now that's going to be an absolute acceptance. Second, I said that it should be unconditional, no further counter offer. If you have made a counter offer, it is rejection of an offer, right? And it is not acceptance. And it must be communicated. Both offerer and offeree should do proper communication of the same. So now the offer must be communicated to the offeree, offerer. Now let's say I sent you a WhatsApp message that, okay, I want to sell this car probably to you, and you are like, okay, that's a great deal, but you did not reply back to me. You liked the deal, right? And you probably, in your mind, you have also started thinking that, okay, this is a deal, I really want to pursue it, but you did not respond it well to me, right? So that means there is no communication happen. So till the time the communication of the acceptance is not done, this is not a complete acceptance. Okay. Very important is the concept of consideration. Okay, now so I mentioned this thing that consideration is anything that you are getting in return. If I, both the parties, they need to get something in return out of a contract. So now A and B, A wants to sell his car to B for 5 lakh rupees. So A is going to get 5 lakh rupees from B. So those 5 lakhs will be the consideration. B is going to get a car from A. The car is going to be the consideration. So anything that you get in return is going to be the consideration, right? So under section 2 clause D of the Indian Contract Act, the term consideration has been explained in detail. And it is said that there can absolutely be no contract without a consideration. Any contract without a consideration will be a void contract. What is a void contract? A contract which has no legal validity. Now, this is the general rule. There is an exception to this general rule. The general rule is that there can be absolutely no contract without a consideration. It's going to be a void contract. The exception to it is given under section 25 of the Indian Contract Act, which says that if an agreement has been done out of love and affection, right, then there can be no consideration. For example, my father wants to gift me a house, right? So now house is not something which he can just lift and give to me, right? He has to, I mean, there has to be proper documentation for the same that has to be done. So now if he wants to give me a house, then the registered document will be made, or probably a gift deed will be made. So now if he has to gift me a house for the same, I am not probably going to pay him, right? So that is something which he's doing out of natural love and affection. So in this case, I am getting the house, right? The consideration for me is the house, but my father probably will not get anything in return. Yeah, so there is no consideration for him. So, but still, this is a valid contract because it is arising out of natural love and affection. It's a what? Um, it's a gift deed. Secondly, any past voluntary act. So, if let's say A and B are friends, A someday paid for B, right? And B in future paid for something for A, right? So that way it is past voluntary act, right? So now in the past, if you have voluntarily done something for someone else, and in future the same person does something for you, right? In a contract, then then there need not be necessarily any consideration involved. Then if there is any time bar debt, okay, when there has been when there is a promise to pay a debt which is barred by time, where the limitation period is over, right? In that case also there can be a consideration without, sorry, there can be a contract without consideration. Very important concept is the concept of competency and agreement by a minor. Competency basically means who can actually enter into a contract for real. Okay. So now the Indian Contract Act says that anybody can enter into a contract, but there are a certain exceptions to the same. Now, what are the exceptions? Sorry, certain conditions, right? What are the conditions? First of all, the conditions have been given under section 11. The condition is that the person should be major. Major means that he should be above the age of 18. Okay. Secondly, he should be of sound mind. Sound mind means that he should not be having any mental illness, right? He should be able to understand the terms and conditions of the contract, and he should also be able to execute it properly, right? Third, he should not be disqualified by law. Disqualified by law means that he should not be a bankrupt, right? He should not be a foreign sovereign, any alien enemy. He should not basically be disqualified by law, right? By legally, even if he is a major, he's of sound mind, but if he is bankrupt, if he's insolvent, or if he's a foreign enemy, in that case, he cannot enter into a contract. So, why? Because the law does not permit them to enter into a contract, right? So, these are the three conditions. One very important concept is the concept of contract with a minor. Okay. So, Indian Contract Act straight away says that any contract done with a minor is going to be void ab initio. Void ab initio means that the contract is going to be void right from the beginning. So, it does not have any legal identity, any legal validity. It is going to be extremely, it just does not exist. It's void. And for the same, there is a important judgment, which is Mohri Bibi versus Damodar Das, where this principle that a minor's contract is going to be void ab initio was established and was found. All right. Okay. Proceeding ahead, the concept of free consent. Okay. So now another very important thing for a contract is that both the parties should enter into a contract voluntarily with their free consent. Okay. Now, what does that mean? It means that the both the parties, what all they consent to enter into a contract for, should not be done under these conditions. First is coercion. Coercion means by threatening or usage of force. If I threaten you that okay, please, you have to enter into, there's no please within a threat. If I threaten you, or if I basically use force, or if I at gunpoint I ask you to enter into a contract, then I am coercing you. This is coercion that I'm using for you to enter into a contract. Okay, so then there is undue influence. Undue influence is when one of the parties is in a dominant position. Let's say teacher and student, parent and kid, all right, um, principal and agent, employee and employer. One of them is in a dominant position, another one is not dominant. So the dominant person use their dominance, use their position to influence the decision of this inferior, right? So in that case, it is going to be a undue influence. Third is fraud. Fraud is an intentional deception, right? You are deceiving someone, or you are causing basically some sort of fraud with someone with an intention to deceive them, right? You're not giving them the correct information. You are misleading them with an intention to basically fraud them, right? That is there. Then there is misrepresentation. Now, misrepresentation is also where you are giving wrong information. Time you're giving this information with an intention to, without any intention to basically deceive anyone, right? So the difference between fraud and misrepresentation is that in fraud there is an intention to deceive, while in misrepresentation there is no intention to deceive anyone. All right. Just give me All right, I'll just quickly get it fixed. Okay. Minor electricity failure, but let's get started. Let's continue. So I was telling you about these things. All right. So I was telling you about things that can influence free consent. All right. So now continuing with, okay, misrepresentation. One very important thing is that the core difference between fraud and misrepresentation is that in fraud, there is an intention to basically deceive the other person. There is an intentional wrong information being given, while in misrepresentation, the information that has been given false is without any intent, right? There is, it is an honest, probably mislead that is there without any intent, right? But the difference here is basically in fraud and misrepresentation, the difference is going to be of the intention. And then is mistake. Mistake is when there is some error about facts or the information that has been given by either party, right? That's a mistake. Now, for all these situations, the contract is going to be a voidable contract. However, in very rare situations where there is mistake at the end of both parties, which is known as a bilateral mistake. When there is a bilateral mistake, then the contract is going to be void. Otherwise, in all other situations, the contract is going to be voidable. I'll explain you what are these contracts as well. Okay. But this is the difference. Always remember, if the mistake is at the end of both the parties, and the contract is going to be void. Okay. All right. I think this one we have explained. Yeah. This is important. Bilateral mistakes, when both the parties are mistaken about the fact, right? Then the agreement is going to be void in nature. Otherwise, if it's a unilateral mistake, right, when only one party is mistaken, then the contract is not void, it's a voidable contract. Okay, so bilateral is going to be void, unilateral is a voidable contract. Okay, then very important is the objective behind the contract. Okay, so the contract is only going to stand still if there is lawful object and lawful consideration, which has been given under section 23 of the Indian Contract Act. It says the purpose behind which you are doing the contract and the consideration that is involved in a contract should be legal. Now, what does that mean? So, lawful purpose, lawful object, first of all. The object basically means the purpose behind why you are actually coming in, getting into a contract. If your contract is, let's say, to sell your car, right? So it's not, selling something is not illegal, it's not forbidden by law. So the purpose is lawful. But now let's say you are entering into a contract of basically killing someone, contract killing. Yeah. So if you are entering into a contract to kill someone, in that case, the objective behind the same is not legal. It's forbidden by law. It's a crime that you are doing. So that contract will be a void contract. It will not have any legal validity. It's going to be a void contract. Secondly, lawful consideration. Now, what is lawful consideration? Consideration, I said that anything that you are getting in return. Okay. So now, if I want to sell you my car and in return you want to give me 5 lakh rupees, then it's a lawful consideration. You're getting a car, I'll get the money. It's absolutely legal. But if I sell you my car and in return you give me something which is forbidden by law, let's say drugs, right? So in that case, the consideration is going to be illegal, something which has been forbidden by law. Okay, so we cannot do that. So those contracts are going to be void agreement. Now, what other contracts are void? So void contract is which does not have any legal validity, which are not enforceable in the court of law. Now, apart from everything that we have discussed, there are a few more contracts which are also void in nature. First is a contract which is of restraint of marriage. If you enter into a contract with someone that you stop them from marrying someone, right? Or you stop or you take away their right to get married to someone, right? So any agreement in a restraint of marriage is going to be a void contract. Same way, if you enter into a contract where you stop a person to carry out a specific profession or trade or business, then you are stopping, then you're restraining them, right? So that is against their right to profession. Then restraint of legal proceedings. If you enter into a contract with someone that for any dispute that happens between you and I, you cannot go to the court. So you are taking away the right to justice, right? Again, it's a void contract. And last is wagering contracts. If you know about, okay, you must have heard about betting in cricket, right? So betting in cricket is something which is not legal and it depends on a future event. So wagering agreements are those agreements where the agreements or the execution of the agreement depends on any future event, any such event which is otherwise not considered legal. So all these cricket bets, right? All this satta thing that you might have heard, it's a wagering contract and it is not something which is illegal. It's a void contract all the time. All right. So any contract where the parties will stand to win or lose depending on any uncertain future event is going to be a void agreement as well. Okay, now what are wagering events? There are two parties with opposite views on an uncertain event, right? One will win, the other will lose, and neither party can control the outcome. It's purely speculative. That means you're just making guesses. For example, betting 5,000 on an IPL match result, it's a void agreement. All right. So, see, there are agreements which depend on future events. For example, we have contingent contracts, right? Contingent contracts. For example, you in buying an insurance policy. Whenever you buy an insurance policy, you buy it in a way that if something, let's say you bought a car policy, right? Car insurance. So the way when you buy it, it's more like that, okay, if something happens to your car, any sort of damage or wear or tear happens to your car, then you can use the policy money, right? But if nothing happens, then the premium that you are paying to the insurance company will be their money. Now it is also based on it also depends on a uncertain future event. Your car might get damaged or might not get damaged, anything might happen, right? But it still depends on a happening of a future event. So in that case, but those contracts are valid contracts. So such valid contracts which depends on future happenings are called contingent contracts. Wagering contracts are similar to contingent contract, but it involves winning or losing of the parties, and both the parties, they do not have any control over the final outcome. And then very important is the concept of breach of contract. Now, breach of contract basically means when any of the parties, they do not abide by the conditions that both the parties had agreed upon. Okay, in a contract there are certain terms and conditions to be followed, and if any party do not do their part well, then it will be considered a breach of contract. Now what, there are two types of breaches that we have. Okay, first is an actual breach, when one party fails to perform at the time of performance, right? For example, A agrees to deliver goods to B on 1st June. On 1st June, A fails to deliver. So this is a breach. Second is anticipatory breach. It occurs when party declares in advance before performance that they will not be able to perform their obligation. For example, A agrees to sell his car to B on 15th. On 1st, he says that, okay, I will not sell. This is an anticipatory breach. You have entered into a contract before you could perform the contract, but after entering into a contract, during that time, you said, I do not want to do this contract anymore with you. Okay, that is an anticipatory breach. You can also sue the other person for the same. Once you sue the party, any party, for breach of contract, there are some remedies that are available in the law of contract. First is damages. Damages means any sort of monetary compensation, money that you will get in return. Second is rescission. Rescission means cancellation of the contract, right? Cancellation of the contract means that now the contract has no validity. It is cancelled. The parties will stand at their original positions the way they were before the contract. And third is injunction. Injunction is where the court orders them temporary stay or gives them stops them temporarily to do something for doing something. And last is specific performance. Specific performance basically is when, let's say, monetary compensation is not enough, some extra effort, some extra actions are required at end of any party, then the court orders the other party to do something. Injunction is when court stops them to doing something for doing something, and specific performance is when the court asks them to do something, right? In apart from just money. Right. So yes, this was about law of contract. If you have any questions in what all we have discussed so far, we can quickly take up your few questions. If no, the class for now. And thank